Hello, I'm Brian Danks of the Robinson Police Department, and on behalf of the Norman T. Richards Lodge number 122 of the Fraternal Order of Police, welcome to the 2012 Crawford County State's Attorney's Debate. As law enforcement officers, we at the FOP take very seriously the way the cases we turn in and the arrests that we make are handled as they travel through the judicial system. Paramount to this process is the job that the state's attorney does. For this reason, we feel that this race is one of the most important local decisions that you will make in November. Furthermore, the members of our FOP Lodge do not feel that endorsing a candidate was something that we wanted to get involved in any way. Whoever gets elected this November is someone that we'll have to work with, and we didn't wish to strain any relationships. That said, we did want to get involved, and we felt that facilitating the informing of the voting public was something that we could do. That brings us to tonight. The rules that we've set forward tonight with Mr. Hartrich and Mr. Lane are as follows. Each candidate gets 3 minutes for an opening statement. After that, each candidate will have 2 minutes to answer the question posed. Then each will get 1 minute of rebuttal time. Follow-up questions may be posed at my discretion, and each candidate will get 1 minute to answer such follow-up questions. The order of answering each question will alternate until all questions have been answered. After all questions have been posed and answered, each candidate will be given 3 minutes for a closing statement. The candidates running for office of Crawford County State's Attorney are Republican Matt Hartrich and Democrat James Lane. Before the debate, a coin flip took place. Mr. Hartrich won that flip and chose to speak second. This order will be in place for the rest of the night.
I'm Jim Lane, and I'm running for candidate for the state's attorney's office. I want to introduce my wife, Marla, who's in the white blouse sitting on the first row. I want to thank the Fraternal Order of Police and WTYE for putting on this debate forum. Now, there's not much time allotted for all the questions and all the answers, and I know we all want to get home to see the presidential debate. I'm not going to do a bio. Most of you know me, and information about me is in the program. I have a lot to say, though, about what plans I have for this office. Anyone wants to have more information, because we don't have a lot of time, come and find me and ask the questions. I'll be glad to answer. Experience is the key here. It's the key to this race. I'm not reinventing the wheel. I have 21 years of experience in 12 surrounding counties. I'm going to be using what works. Now, I'm not going to be negative, and I'm not going to be negative towards anyone here or anything tonight. If I talk about what works and what doesn't work, I'm not talking about individuals, but I've worked with a lot of state's attorneys, some good, some that didn't get reelected. I've worked with judges, and I've worked with different courts and clerks. I know what works and what doesn't. Being negative just doesn't help. The position here is not a job. It takes passion, street smarts. It takes a little bit of experience. It takes listening. I think it takes preparation and communication. It also takes a little bit of parenting. It takes giving direction. It takes hope. It takes helping people with their self-esteem issues. The state's attorney is the voice of the people. A tough, firm prosecutor, but also a caring person. I heard a prosecutor say, I can take the heat. Well, folks, I want to create the heat. I think what we need here is someone who can come in with a fresh perspective. Someone that can come into this office and give firm but fair prosecution, because that's what justice is.
Hello, I'm Matthew Hartrich. I don't know if everyone can hear me in the room. I'm the Republican candidate for State's Attorney in Crawford County. I'd like to start by thanking everyone for coming and thanking WTYE and the Fraternal Order of Police for hosting this event. I'll just briefly give some background myself. I know it's outlined in the brochure that the people here have, but people on the radio don't have it. I graduated from Robinson High School in 1996 as class valedictorian. I'm a native of Crawford County. I graduated 3 years later from the University of Illinois College of Law with a degree in economics and with high honors. I also then graduated 3 years later from the University of Illinois College. I did the University of Illinois in 1999 and the University of Illinois College of Law in 2002, and was admitted to the practice of law that year. I've served as the Crawford County Public Defender since 2005, and I've also previously served as an Assistant State's Attorney in Champaign County, Illinois, so I've experience in both the prosecution and defense side of the bar, and have experience in both serious felony, misdemeanor, and juvenile cases, including acting as guardian ad litem and defense counsel. But ultimately, as state's attorney, I wish to make the Crawford County judicial system fair, more efficient, more effective, and ultimately I believe that the people of Crawford County would be served better by a more timely resolution of cases, with better coordination with law enforcement, victims, and witnesses. So I thank everyone for coming, and I look forward to your questions. Thank you.
Okay, first question, Jim, this is yours. You both have been involved in handling cases in Crawford County. Your experiences here give you each a very good basic knowledge of our local society and its court. Given your experience, what is the biggest criminal problem in our county, and what is your ideology on how to best mediate or abate this problem?
One of the biggest problems that we have in Crawford County is a backlog of cases that have clogged the system. As of last week, folks, we had 1,099 cases where no one had entered a plea. We had 114 DUIs that were pending. These are people that aren't being brought to justice. There are people where, in my belief, justice delayed is justice denied. What I will do if I'm elected to the state's attorney's office, I will help manage the caseload. We work in other counties with about a 90-day turnaround. And we're very conscious about who's in jail, who's out, what cases are setting out, and we get those cases done. We don't go 30 to 45 days between having hearings, and we don't go for days and days and days without an offer being made. The state's attorneys evaluate the cases. The state's attorneys give discovery to the defendants and to their counsel. The state's attorneys give us the knowledge and information so that we can get cases done and cases completed. I think that that's really the biggest issue that we've had here over the last few years, is cases just languish and languish. I would hate to be a victim that has to sit for 6, 8, 10, 12 months before my case comes to court. I don't know what's going to happen with it. I don't think that's fair to anyone. I think I have the experience to evaluate a case and say what it's worth. It's not something that you just learn in college. It's nothing that you can pick up from a book. It has to be something that you acquire over the years so that you have the ability to evaluate those cases and say what they're worth. Not every case is worth the maximum. You have to look at it and be firm but fair.
Matt?
Officer Jenkins, I believe that the most serious criminal issue facing the people of Crawford County is involving drug sales and drug manufacturing cases. That the best way to deal with those type of cases is to coordinate with local drug enforcement officials and police officers in order to determine the highest priority cases, focusing primarily on those involved in manufacturing of methamphetamine and other drugs, and particularly delivery and sale of drugs, focusing on those people and seeking to prioritize the people who are involved in the distribution of narcotics, and to prioritize those cases to focus on incarcerating those who are distributing drugs in our community, and lesser so than the people involved in simple possession without any type of manufacturing or delivery. It is important, of course, to move cases in a timely and expeditious manner. I believe that could be accomplished better by faster discovery, disclosure, making plea offers for cases in a more expeditious manner. And as a result, I think that things could be turned around in a more expeditious manner than is currently done. Thank you.
Jim, you have a minute? 5 minutes.
Obviously, drugs are a major issue with what we have going on. We do have a drug court program, and it's a good program. It's probably the leading program of anyone in our circuit. They have the first fundraising segment that they've used. Drug court works. I've used it on an informal basis for many years. It does work. It has upside with close monitoring of people, but it has the element that if you screw up, it's your last resort. It's the last place that you get to go. So if you screw up, you're going to prison. What really bothers me, and continues and continues and continues, is we have the same names, the same offenders coming in back into court time after time after time. Those people need to be dealt with, either through drug court or going to prison.
Well, Mr. Lane brought up drug court. I am familiar with the drug court system. I actually was part of a participant in creating the drug court. Here is done in the direction of Judge Weber, and specifically have referred 4 of the 8 people that are currently in the drug court program. The drug court program focuses on nonviolent drug offenders, primarily ones who are not involved in manufacturing and delivery of drugs. It can be effective because it involves intense supervision of the drug court participants and presumably, or is supposed to occur, counseling and other resources to attempt to deal with the underlying issues for their drug use. So I'm familiar with the program and actually am an active participant in it, and I believe that its expansion, which actually is intended to occur within the next year, would be appropriate for nonviolent drug offenders. Thank you.
Matt, you can stay there if you want, if you get this one first.
Okay, thank you.
Switch gears just a little bit and talk about the public as a whole a little bit. The public obviously has a vested interest in what you do as state's attorney or what you will do. Given the caseload of the state's attorney, it is becoming more and more difficult for the public to access and engage the state's attorney. Is there any way that you can improve public access to their state's attorney?
Well, I guess obviously you have to deal with the pending cases that are in the court system and prioritize that, but it is important for the state's attorney to be available to the members of the public. I think that obviously victims of cases and complaining witnesses are people who need to be prioritized. You need to be able to communicate with them. I suppose it could be possible to have an open forum maybe every couple of months to allow the state's attorney and the public to communicate about the priority of cases. But I think it's most important to have a policy of being open to communications with the public, to allow the people to know that you have their concerns in mind, specifically even just when out in the community, at your church, particularly when you attend church. And I believe really it's going door to door and seeing people on a daily basis. People have expressed desire to me for firm prosecution, but also fair. And I've been getting a lot of good feedback from the community. And I would basically just be open to feedback from the public in general throughout my tenure as state's attorney.
I think the state's attorney's office needs to have an open door policy. Needs to have time every week for someone to come in and talk to you and talk to me. You need to be open for people so that we can answer questions. Communication is the key. I'm going to pull out my cell phone. Why can't we communicate? We haven't communicated in many years. This isn't an old group. This is a new group. We're technology savvy. Our kids know more about technology than anyone else. I think we can communicate. I think we can do a better job of getting to the people and letting them know. We can educate. My background is in education, and I've spent many years working with the college in education. I think we can continue on with our education in schools to educate and help people understand about bullying, to understand about drugs, to understand about the synthetic drugs that are going on right now with the kids. We can educate folks about how to keep safe and how to report crimes and to know that they're not going to be pulled in and ostracized or talked about if they report a crime. My office will be open to the police and the law officials. I intend to meet and know what's going on. I want to know what the other officers are working on, what cases they're investigating, what leads they're working on. I want to know. I want to be able to communicate that. We can't talk about individuals with their juvenile cases or individual cases that are going on. I certainly don't want to mess up something in the middle of a case and give somebody some grounds to get out of something. But I'm going to be open and honest, and I'm going to talk to people when they want to talk. And when cases are done, we're going to make sure that the information gets to the media so they know. Because I want people that are out there committing crimes to know that it's a get tough policy and we're not going to take it anymore.
I guess the one I guess I haven't made, and it's not a minute point to prevent anyone from speaking to the state's attorney, is the state's attorney is forbidden from providing legal advice to members of the public other than the county. The state's attorney acts as the prosecuting authority for all criminal cases, and also advises the county board and other county officials in his capacity as state's attorney, but he's actually forbidden from providing legal advice to members of the public. So one specific thing is you can provide general direction and receive information from the public as to how they believe you should pursue cases, but you can't provide legal advice because that's actually forbidden by law. And then specifically, you can't do anything to discuss any pending cases that could potentially, one thing that's forbidden by the rules of professional conduct if you would express to the media or someone something that could prejudice the defendant. So you have to, it's a very delicate balancing act as to how you proceed that way. I think my time has expired.
Okay.
The state's attorney's office needs to be proactive, not reactive. In the past, we've been reactive. We wait until the crime happens, and then we go after it. I think the state's attorney can be proactive. They can get out there and let the criminals know this isn't going to be tolerated. We can do that by being open with people and being available to answer questions.
Jim, you stay up there because the next question is yours first. And we're going to talk about drug court. I know you guys both have some pretty strong feelings about drug court, but in case people don't know, drug court is an unfunded mandate by the state. And some argue that drug courts are just more smoke and mirrors used to defray costs back to the local jurisdictions by keeping repeat drug offenders out of prison, while others claim that it gives drug offenders a last chance to avoid prison while having to maintain a strict regimen of guidelines set by the court. First of all, what is your opinion of drug court? And if we're not going to send these drug offenders to prison, should we significantly raise fines and costs to defray the increasing cost of drug enforcement?
Thank you. I do have a long history with the drug court on an informal basis and now on a formal basis. Drug court, folks, is for a very select few. It's not for everybody. It is an intense, sometimes inpatient, sometimes outpatient. It's closely monitored program. Crawford County, as I said before, is the leader in the fundraising part of it. It's an unfunded mandate, which means the state doesn't give us money to operate it. It is cost effective. It runs us about $2,000 versus $20,000 to house an inmate every year. The key to a drug court is the personnel, counseling, and participation. Drug court is not a necessary evil. Good things happen. We need to keep addicts in check, and we need to help them. If that drug addict doesn't get help, he goes to prison. Does he come out and do drugs again? Most of the time, yes, he does. And he reoffends. And he doesn't get it, or she doesn't get a job. And they don't contribute anything back to this county. Everyone in this room pays for them and pays for their care. Drug court is a place of last resort. said before, if you screw up while you're in drug court, you're going to go to prison. If that doesn't mean something to somebody, then they have a problem. Now, we don't pick people that we know are going to be good candidates for drug court. We pick people that are at the very last part of their rope and want help. We don't just pick all the winners. It doesn't work that way. But I think people are worth being saved. And I'm not really ready to give up on some of those people. Other people, they just need to be taken out of society. But there's a few among us with drug addictions that we can work with and we can monitor weekly, almost daily.
Thank you. Yes, drug court was mandated by the Illinois General Assembly. It was implemented by order in Crawford County in January 2011. The first person in Crawford County was actually admitted to drug court in April 2011. The people I believe are ideal for admission into drug court are people who are involved in nonviolent drug offenses, who weren't involved in the manufacturing and delivery of narcotics to other individuals, who express a specific desire to get off drugs, and that through their behavior and demeanor to the court and the judicial system appear to have to be serious about their desire to kick their addiction to drugs. The drug court program involves intensive supervision with weekly updates in court, and also often 2 or 3 times the person is seen by the drug court officer, and often there's weekly counseling and sometimes group counseling. It is potentially an important component of rehabilitation for nonviolent drug offenders, but it's a matter of determining who is an appropriate person and who is someone that needs to be incarcerated. And that is where the discretion of the state's attorney comes in. As state's attorney, I would monitor each case thoroughly to determine if someone's an appropriate candidate for drug court, and if they're not, I would exercise my authority as state's attorney to veto that person. Also, I think you brought up an issue about fines in the question, and I do believe it is appropriate to increase fines in certain drug cases to cover or defray the costs of such programs. It is true, though, that the Crawford County Drug Court just received word today that they're going to be receiving a grant from the state of, I believe it's $76,000, to defer costs of the drug court and allow some additional programs that can be helpful in. Thank you.
Thank you. One obvious thing about drug court, it gets a guilty plea. We don't have somebody sitting in jail waiting month after month for their trial. They enter a guilty plea. They're sentenced. We hold up on some of those going to prison thoughts to see if we can help them get rehabilitated. Years ago, we sent somebody off for 28 days. And we said, go to drug rehab, 28 days. You're going to be cured and you're never going to do meth again. That didn't work. It was a complete failure. 28 days doesn't work. It takes months and months and months. Sometimes it takes years. It takes helping people get away from the crowd that they've been hanging out with. It takes somebody holding something over their head. It takes a counselor. It takes the probation officer that's willing to put the time in to help those people if they want the help. I think drug court is a good alternative. I want to have those folks out working, paying taxes, earning a living, taking care of their children.
Well, I guess one thing that needs to be pointed out is that the reason why it's necessary to be so selective as to who you admit to drug court is that by nature of the very program and the intensive nature that only a limited number of people can be at the program at a time. Currently there are 8 members in the Crawford County Drug Court. As I said, 4 of them were referred by me. The discussion of the drug court program is expanding within the next, I believe it's 6 to 9 months, I'm not exactly sure about timetable, to approximately 14 people. And I believe that it's necessary because of the limited nature and the intensive nature of the program that the state attorneys be very judicious, select the people who are most likely to benefit from the program and focus on those individuals. And then after that, individuals who are particularly commit more serious crimes and are involved in dealing or manufacturing drugs to focus on incarceration for those people because they are more of a detriment to the community. Thank you.
Next one's yours, Matt. Okay, this is something that I know is important to the sheriff, and so put on your county board attorney hat now. As we all know, the county, like other entities, they're strapped for cash. The sheriff has an almost impossible task of budgeting for the jail and the care of the inmates. An issue that has been the subject of some argument is that of inmate medical care. Should the county pay for inmate medical care that is not related to their incarceration, and why or why not?
Well, I guess it depends upon the nature of medical care. If it's medical care of an emergency or crucial nature, the county, as long as the person is incarcerated, the county has to pay for it because the U.S. and Illinois Supreme Court is required that they do so because they've held under previous case law that it's a violation of the Constitution not to provide necessary and emergency medical care. The state's attorney can potentially help, depending upon the nature of the case. If it's a less serious case, particularly misdemeanors or other types of, maybe some less serious felonies, there can be the possibility of releasing the person if it's going to be an extreme cost to the county. But obviously, if it's a serious felony case, murder or rape, predatory criminal sexual assault, a drug dealer, you aren't going to want to release someone in the community who's going to further injure or damage the community to reduce the cost and have someone, another child or someone raped. But unfortunately, well, I guess, depending on your point of view, if it's a necessary medical cost, U.S. Supreme Court requires the county cover it. So, thank you.
I can tell you what works in the other counties. We communicate. We talk. We get calls, and by we, I mean the state's attorney and the appointed attorneys. We get calls from the jail. Sometimes we get calls from the officers in the middle of the night saying they arrested somebody that has a serious medical problem. Sometimes from the jailers say there's a staph infection or there's something else that's really seriously wrong. Someone's pregnant. We move those cases through. We deal with the people so that they're not in jail when they're going to infect anyone else, or so that they're not there if they have a serious medical condition. By communicating, sometimes on a daily basis, but at least on a weekly basis, we know who's in trouble, who's in the hospital, who's needing to see a doctor, who's needing medications. By doing that, we sometimes put those cases on the front burner, and we work on them quicker to get those folks through the system and get them out of our jail. I think we have too many people in jail here. What we do in other counties is we have a daily jail log. And we look at that log every day to see who's in custody. And we know, because we have a good communication system with the sheriff's department, with the jailers, who we need to deal with and who we need to get moved out of the jail. They're not only a threat to the county for liability, they're a threat to themselves, they're a threat to other people that are in there that might be infected. I think if we communicate on a daily basis, we can help this medical cost that is mandated. We have situations in some of the counties where the jailers will help people get a medical card. We'll help them get help. If they have mental health issues, we help them get to a mental health facility. We help them get to a drug rehab facility. And it works. And we save a lot of money in a lot of the other jails.
It is true the judicious resolution of cases is important really for every case, not just for cases that can result in higher costs to the county. I guess the one issue about that is that obviously only a certain number of cases can go to trial each month, and the ultimate determination is for each case is what is an appropriate disposition in that case. So ultimately, other than taking the case to trial, which can happen and should happen in the appropriate cases, the cases can get sped along too much faster unless in a serious case unless you essentially give the person a substantially better plea deal than they otherwise would just because they have a better medical condition. And I also don't believe someone who committed a criminal sexual assault or a predatory criminal sexual assault should get out of it just because they have a medical condition. So, and in those type of cases, it's often necessary. You have to talk to a variety of witnesses. You have to sometimes consult with medical personnel. It's necessary to resolve the case as needed, but you don't want to give someone a better deal just because they have a medical problem. Thank you.
I'm certainly not talking about giving anybody a better deal. I'm just talking about move the case through, get the facts out, get the evidence out to the defense attorney, get things going to where we get people taken care of. The jail should be for detaining people prior to their trial. If we have to have a trial, we can have it quickly. We can move things up so that those folks aren't sitting in jail. It's also for someone who there might be a flight risk. If you're a serious medical issue person, many times you're not a flight risk. If you're a pregnant woman, you're probably not a flight risk. If someone is in jail for their own safety or to help them, sure, we can do some things. But I don't think we need to be having people sit in jail for months at a time and have the county have to pay the money for it.
Jim, might as well stay there. Next question. This is my favorite one because this is, I guess, my pet peeve in the last 22 years. Probation was established as a method of keeping people out of jail while attempting to modify their behavior. They are given guidelines by the court, and if those guidelines are violated, the offenders risk incarceration. We see more and more offenders who have been on probation multiple times, or ones that violate their terms but are then not incarcerated. What do you see as the role of probation, and should probation have more teeth?
Thank you. The statute says that probation is a preferred disposition to be considered by the court. We have a good probation system here. We have good probation officers here. We need to take some steps to help with inpatient assistance for people that are having drug addictions, and we need to help with drug court needs. I think we need to do more with community service. I think we need to closely monitor the folks that are on probation. I agree with Mr. Danks. It's frustrating, and I don't like the fact that little happens when somebody violates their probation. To be honest, I don't have any patience for those folks. If I give you a break and put you on probation and you continue to violate and you commit other crimes, I'm not very patient with giving you another break. I think if someone has shown me that they don't want to abide by the rules, that it's time to put them away and give them a sentence.
I believe that is a very good question, specifically concerning probation. And it is essentially a second chance for someone to receive a court disposition other than incarceration. I believe that the best way to deal with probation violation, it depends upon what type of violation it is. If it's a minor violation or a major violation. Maybe they missed 1 or 2 appointments, or maybe they committed a new criminal offense, which is obviously substantially more serious. If it's a minor violation, then I could see having a violation of probation, giving the person a short jail sentence, telling them they need to continue their probation and learn that essentially that if they do it again, that the jail sentence will increase or potentially incarceration in the Department of Corrections, assuming it's a felony probation. But if it's a major violation, then I think that there needs to be a desire to seek to quickly violate the probation, set it down for a probation violation hearing, and to seek incarceration when needed, because essentially the person who's put on probation was given a break, and they need to learn that following the consequences of their actions are important, and that they can't just snub their nose at the court system. Thank you.
I think that idea is what's kept this problem going. I think that idea is why Mr. Danks asked the question that he asked. I just don't have the patience. I want people out working, doing the things that they're supposed to do, not violating. They know what's expected of them. If you can't make it to your probation appointment, What do? Do you just not show up? I bet you can call, they're going to be there. I know people call the probation officer in the middle of the night. She's told me. The probation officer can be somebody you can go to for help. They're not the enemy. I'm just not in favor of giving people break after break after break and watching them offend over and over and over.
Well, I guess I'd first say I don't think that's a correct characterization of what I stated. What I was saying is you have graduation of punishments. I didn't say give a break after break, so I would say what you said was really accurate. But what I was stating was based on what type of violation was occurred that you have different levels of punishment. And I would also say that people that call a probation officer at home at night are law enforcement officers, not probationers, because they don't get a phone number. But basically what I'm saying is for serious felony cases, when there's serious offenses for violation, it is necessary that you should seek to violate the probation and send the person to prison. If it's a more minor violation, you can start with a graduated elevation of punishment, including county jail time, increase the county jail sentence if necessary, and then seeking time in the Department of Corrections. Of course, if it's a misdemeanor probation, seeking time in the Department of Corrections is not a possibility because that is not a possible sentence from the court. But I do believe that it's necessary to have a community service option as part of probation when appropriate, but it's not really considered a punishment, but just a term of probation. Thank you.
Matt? Last question.
Ready?
Already? Our voters have many things to consider when choosing a candidate to vote for. For them to make that choice, they need to know how each candidate feels about the office they are running for. In the 22 years that I've been here, I've done this job as state's attorney, started with John Anderson. We had Mark Shaner, Jay Holtzhauser, and now Tom Wiseman. And each of those people had very different characteristics about how they handled their office and their job. In your opinion, what is the most vital characteristic of a good prosecutor?
What is the most vital characteristic of a good prosecutor? I believe the most vital characteristic of a good prosecutor is someone who truly believes in doing what is right. I think that he has to be a person who has strong convictions, who came from a family with strong convictions, that he knows who he is as a person and believes in looking and evaluating each case for its merits and is willing to consider each person, each facts, the witnesses, the complaining victims, and look at all the information that has come before him for that matter, and is able to evaluate each case with an open mind and look at everything fairly and appropriately.
I think I've known Mr. Danks since the first year that I started being an attorney here. And we've gone through a lot of different state's attorneys. We've gone through different state's attorneys in other counties. We've seen what works and what doesn't work. You asked about the trait of the state's attorney. I think one of the most important traits is the state's attorney needs to be somebody who can look at a case and who can tell what it's worth. Now, what I mean by that is, a state's attorney has to be able to evaluate a case. They have to be able to make a recommendation. They have to be able to make a decision. They have to be able to do it on a timely basis. They have to communicate that decision after they've talked to the victim, after they've talked to the law authorities. But it takes a lot of time to learn how to evaluate a case. It isn't something that you just are born with. It takes a lot of time for the officers to evaluate a case. They've learned, and we have good officers as a result of that. So you ask what's the number one quality? I think it needs to be somebody who can correctly and appropriately evaluate a case and decide what's it worth.
I guess I'm not sure if I'm supposed to get a rebuttal when I say I disagree with this bit or not, but I guess to expand on more of what I had to state on the issue, I believe that what's appropriate is that someone knows who they are as a person, knows the law, is familiar with the legal system, and specifically is willing to make a decision. That is true. Being willing to make a decision is very important, because if you're someone who is unable to make a decision on a timely basis, then that specifically does result in the delay of cases. I have no problem making decisions. I will be decisive, and I will not have any difficulty in making appropriate determinations towards the beginning of the case as to what I think is an appropriate disposition.
The state's attorney has a job to be a little bit of everything for everybody. They need to be a legal counsel for the county board. They need to try to work with the law enforcement. They need to try to work with the defense counsel. They need to try to make the judges happy. They need to try to make the circuit clerk happy. We even have a job to make sure we're keeping the court reporter happy. I guess number one, we also need to keep our office staff happy. You have to have some leadership qualities to be able to do that. You have to have some experience of working with people to do that. I think I have that experience. I think I have that quality. I think you have to have a little bit of a bulldog in you. You got to be willing to sink your teeth into something and hang on and ride it till the very end. I think I have that. I wouldn't be up here asking for a vote for this office if I didn't think I had what it takes to be that person.
I just wanted to talk. You each have 3 minutes for closing statement, and Matt wants to go last, so Jim, this is your closing statement.
Thank you. When we started, I'll admit I've never done one of these before, so it's kind of a new thing. But I told you I wasn't going to be negative. Crawford County is the best place to live. I've lived in different places. If I didn't love Crawford County, I would have moved a long time ago. It's the best place. Now, Mr. Wiseman alone didn't get us into this situation. But the voters spoke, and they said they weren't happy or they weren't satisfied with what was going on in the current situation. We have good judges. We have good staff. We have a good circuit clerk. We have good police officers. Second to none. I work in other counties. I know. Together, I think we can make this program work. I have a plan. And it's a plan that's based on 21 years of experience. I'm going to use what I've learned, what I've picked up in the other courts, what I've seen that works and what doesn't work. And I brought it up a minute ago, I advertised I'm a bulldog. Well, I guess some of you have been on one side of a case or another that I've been involved with. You know that I work hard, I fight for my clients, whoever I take on. You know I don't give up. And you know that I'm committed to that person. The state's attorney represents the people, not the office, not the police, not the court, but the people. I'm passionate about this. I think you can tell. I promise to work hard and try to have your trust at all times. When you decide who to vote for, I ask you to look for experience and commitment. I ask you to look for someone who will bring a fresh perspective to the office. Someone who can bring in the outside ideas to make the changes that are needed. Thank you.
I'd like to start it again by thanking everyone for coming, for the FOP and the WTYE for having this forum or debate for this evening. I guess ultimately what I'm asking is for everyone to take their role in the electoral process seriously. I believe that I'm the best candidate for state's attorney, and specifically, I believe that I intend to work with law enforcement officers to try to have a more decisive, speedier resolution of cases. But ultimately, I think what is necessary for state's attorney is for someone to have convictions and come from a background such that they know who they are and are willing to do what is right and have integrity. I really wasn't sure what I was going to discuss for my closing arguments. I'm kind of making this up as I go. But when I think back about integrity and work ethic, I think about my father. And ultimately, he is the best man I've ever known. And he is the person from which I look for guidance every day. Every day. When he died a year ago, I knew I'd never be a better man in my entire life. And his ability to love, to be decisive, he always knew what was right, and he always did what he believed was right. And his ability to raise 9 children, be with my mother for 46 years, and to always know that no matter what, he was going to do what he believed was right, is the guidepost for me in my life. And I will always follow his example. And ultimately, he was the person that first suggested to me, before he died, that I should run for state's attorney. And his example is one I will always follow as state's attorney. Thank you.
Okay. Well, I'd like to thank Mr. Hartrich and Mr. Lane for their participation tonight. Matt, Jim, we look forward to working with whoever the winner is after November. Thank you to Chris Ford and WTYU Radio for their support and coverage of tonight's debate. And thank all of you for coming out tonight. Please take ownership in your community. Go vote this November. It is our opinion that there's no hole in the ballot that you'll punch this November in any race that will affect you any more than your local state's attorney. And so please go vote. Night.